It's a pleasure to introduce Elaine Banton. Elaine is a barrister from 7 Bedford Row and specialises in employment, discrimination, equality law and human rights. Elaine is going to talk about a case concerning whether the Self-Employment Income Support Scheme is discriminatory against women on maternity leave. Thank you so much for joining me, Elaine.
Thank you, Matt, for your introduction. Pregnancy discrimination is a real issue. The Equality and Human Rights Commission in 2015 found that 54,000 pregnant women are forced out of their jobs each year, but only 1% bring claims before an employment tribunal. During the pandemic, there's been much commentary on women being more likely to be furloughed and also undertaking the lion's share of housework and childcare. It has been likened to going back to the 1950s, and not in a good way. This case was a judicial review, and it was brought by the Motherhood plan, also known as Pregnant Then Screwed, and was against HM Treasury and HM Revenues and Customs were an interested party. It's quite a dense read, so I want to give you an overview, if I may. The SEISS scheme was brought in fairly swiftly. The purpose of the scheme was to support self-employed workers during lockdown and COVID. The scope of the scheme was based on ATP, average trading profits, for the preceding 3 tax years, 2016-17, 2017-18, 2018 and 19. Alternatively, it would apply for those in 2018-19 and 2019-20, and those who intended to then trade in 2020-21. But you had to have profits that were less than 50,000 per annum. That's profits. One feature of the scheme was to make it less simple and less amenable to fraud, was of course to rely on information that had already been submitted to the government, and so preceding tax details. The claimant's arguments really involved 2 main grounds. The first one was that there were 2 types of discrimination at play. The sort of conventional type of discrimination, indirect discrimination, as seen under Section 19 of the Equality Act. The second type of discrimination we are talking about is found by way of Article 14, read in conjunction with Article 1 of Protocol 1 of the European Convention on Human Rights. This type of discrimination we call flemenos type of discrimination. And in order to bring that type of claim, you do need to piggyback it in respect of another article under the ECHR, as it was brought in this case. The second type of argument that claimants raised was that there was a breach of the public sector equality duty. Now that's Section 149 of the Equality Act. And that's where you have to have a due regard to eliminate discrimination and promote equality of opportunity. It's a proactive duty that falls on public bodies or public authorities. In a nutshell, the claimants asserted that if they were absent due to pregnancy or maternity leave, this would reduce the overall claim disproportionately, and this was discriminatory. Pregnancy and maternity are unique statuses, and that no comparator is required under the Equality Act, for example, under provisions sections 17 and 18 of the Equality Act. So the operation of the provision, criterion or practice, whilst neutral, would be leading to this disadvantage and would not be objectively justified by showing a proportionate means of achieving a legitimate aim. The flemenos type argument is similar, but it relies on the fact that if you treat everybody the same, you may end up discriminating against particular groups. It's rather similar to the difference between equality and equity. And it's also a little bit similar to how you might make reasonable adjustments in disability cases. In fact, the claimants argued that an adjustment should have been made to take account of lost earnings related to maternity leave or pregnancy and childbirth. Under the PSED, Public Sector Equality Duty, they argued that the adverse impact there led to a reduction in the ATP and was not considered at the appropriate stage by the government. It had not been identified and considered appropriately. That was the argument. Just a side note on this, when you link up arguments under indirect discrimination with the Public Sector Equality Duty, it is often an effective way to challenge discrimination against public bodies, especially the systemic type of discrimination where you are seeking to break down barriers in various fields. Just a side note. Now, the defence was effectively adopted as the winning judgment. So I'm just going to deal with what the judgment found. The judgment found that there was no discrimination at all. There was no indirect discrimination or hidden barriers to eligibility of the scheme. The payment prevented no hidden barrier either because it was based on the ATP, and that applied to everybody. It was not harder for women on maternity leave to calculate their payments compared to someone who was not on maternity leave. And crucially, the court found that the disadvantage was not caused by the measure, but was independent of the measure. And they relied on the case of Adiatu to that effect. The judgment also specifically found that the scheme's failure to rectify what was termed historic disadvantage was not discrimination regarding previous year's earnings. It also found that if the decision was wrong on indirect discrimination, that it would be objectively justified. And the test that was applied was whether the scheme was manifestly without reasonable foundation. If there was discrimination, it was in fact justified for policy reasons and other factors such as perverse effects. The judgment actually found that if one tried to ameliorate the disadvantage, as advanced by the claimants, that could actually create more hard cases and more complexity. The judgment also found that in respect of the public sector equality duty, the general implications for mothers who had recently taken maternity leave was considered by the defendant at a relatively early stage, and those issues were appropriately considered. So just to summarise, the judgment found that there was no indirect discrimination and that the scheme didn't pose any hidden barriers. The ATP was applied to all equally, and it was not harder for a woman to calculate if they'd been on maternity leave or not, and found that there was no breach of the public sector equality duty.
Thanks, Elaine. That was great. Do you think that the decision was correct and that the outcome was fair?
That's a good question. Is this correct and is it fair? Well, possibly it's correct in terms of justification for indirect discrimination. I do see the force in both sides of the argument. However, personally, in terms of fairness, I would have liked to have seen some adjustment to take account of the unique position engendered by pregnancy, maternity, or having a young baby. In respect of the public sector equality duty, I wasn't convinced that that was appropriately considered by the government at the earliest stage. I really do think this case is a must-read for anyone interested in indirect discrimination or the public sector equality duty, as it reviews some recent cases.
Thank you, Elaine. That was great. Thank you so much for coming on the channel and breaking the case down, making it easier for people to understand. Thank you.
Thanks for having me today, and I hope this has been helpful.
For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.